Uma Gabriel, and we sincerely apologize that we're starting very late. We honor, your time, and therefore, despite the fact that the room is not yet full, we'll go ahead and start. But I would like to appreciate each one of you for being here on time, for giving your time to be present for this forum, and we hope that we'll have a good discussion. We have people that are joining us virtually, and people joining us virtually, apologies that you had to wait without knowing what was going on. I think many people got caught up in the traffic. They underestimated the chaos around the industrial area, but they will be joining us as we go along with this forum today. In the room, we have justices of the Supreme Court, the Court of Appeal. We have judges of the High Court. From looking at the attendance list, those who have signed in, we don't have any magistrates yet, but we are expecting some magistrates. We have in the room representatives from civil society, academia, and whichever category you fall in, would like to welcome you. And we're going to start with the national anthem, and then we'll go straight into our program for today. Would like to thank Cepil, which is the Center for Public Interest Law, for convening us, and we will be hearing from Cepil in a short while. The team manning the sound. Do you have the anthem? All right. Could we please rise for the anthem? Lord, we thank you for gathering us here today for the Rule of Law Forum 2021. We pray that our discussion today will continue to build the rule of law in our country, continue to inspire us to do what is right, and may you be glorified in everything we do. In your name we pray. Amen. You may be seated. Our theme today is examining the role of different stakeholders in the promotion and protection of the rule of law. We will recall that not too long ago, a law was passed for the enforcement of human rights, and especially civil society organizations were very excited about what that would mean for the rule of law. But for avoidance of doubt, rule of law encompasses many things. And I'm not going to attempt to list everything that's included or that's encompassed in the rule of law, but it includes things like supremacy of the law, equality before the law, human rights, following of due process, transparency and accountability, checks and balances, and I could go on and on and on. And so even as we talk about rule of law today, that and more is what we shall be talking about. Would like to start with some opening remarks from our conveners. That is Cepil. Cepil is the Center for Public Interest Law, and it is my pleasure to welcome the Executive Director of Cepil, Mr. Francis Obonyo. Francis, over to you.
We know under the rule of law there are three institutions: Parliament, the legislature, and the executive. But we cannot leave out the public. This is a conversation that has to continually happen because each and every day situations evolve and there is need for constant transition in how we approach or engage the tools that we have at our disposal to help us promote and advance the rule of law. The reason as to why the theme for this event is examining the role of different stakeholders is because the intention is to bring to the attention of everyone who is attending here and all those online that different stakeholders have a huge role to play with regards to promoting the rule of law. Putting that aside, the public themselves, who are supposed to abide by the law, are also supposed to be involved. One of the fundamental principles of Cepil is to promote public interest participation in the lawmaking process. At the same time, to engage the public to help transform policies and laws across the whole board. It is also for that very reason that we have the Rule of Law Champions Initiative, which aims at empowering young lawyers to be able to stand firm and be the pillars to promote and advance the rule of law. But that cannot be done on our own. We cannot do that independently. That is why we call on the different stakeholders to get involved. Being young lawyers, we have a lot to learn. Being young lawyers, we are not exposed to much. Hence the need to continually engage with different stakeholders to understand their roles, their place in all that is related to the rule of law. Justices of the Supreme Court, Justices of the Court of Appeal, the Principal Judge, the Honorable Minister of Justice and Constitutional Affairs, Judges of the High Court, Your Excellency the Ambassadors, Heads of Commission, Heads of Jealous Institutions, the Chief Registrar, Secretary to the Judiciary, the President Uganda Law Society, Your Worship, members of the Bar, ladies and gentlemen, I welcome you to this event. Thank you.
Thank you very much, Francis. So later in the day, when you hear anybody say protocol observed, please take note that what he finished with, that's the protocol we shall be referring to. I believe, also, that expression of protocol. You have an idea of who we're expecting today from the judiciary, from the executive, and I didn't hear him say honorable members, so I don't know if anybody from the legislature will be coming, but we'll have people, a representation from the bar as well, and be expectant as these seats get filled, but also some of our participants will be joining us online. We're going to begin with a panel discussion, a panel that will be looking at the human rights law review. Just reviewing human rights law in Uganda. And particularly, our particular focus will be on the law I referred to that was passed, paused, and just checking whether, it has lived up to the excitement it had created. Many organizations, many entities had pushed for this law. And its passing and the president assenting to it was really received with a lot of anticipation. We also know that, there were issues being found, by judicial officers in relation to enforcement of certain things, and therefore, you go ahead and make a judgment, but how is that even going to be enforced? So I'd like to invite to the front. We'll have our panelists just join us here at the front. Our first panelist, Ms. Goreth Ayebale. She's from Justice Centers Uganda. Goreth, you're welcome. Also joining her on the panel is Ms. Atim Patricia, the head clinical legal education, PILAC. If you're looking at the program, we're supposed to have one other panelist, but she had to step out to attend to something. If she does make it back before we're done with this panel, and I intend to really keep it short so that we can move on to a number of presentations that we have. We have a report on the judiciary scorecard and wouldn't like to keep you beyond the time we said we'd have you here. So despite the late start, we still intend to end on time. So yes, please bear with me if we go through this panel a bit quickly and move on to the other activities. All right, I'd like to start with you, Patricia. If you could begin, and there are microphones right in front of you on the table. Since there's just two of you, there will be a microphone apiece. All right. Let's just begin by understanding what the organization you come from, PILAC, does.
Good morning, everybody. And I think I'll then say all protocol duly observed. I recognize each and every one of you in your respective capacities. What does PILAC do? PILAC is the Public Interest Law Clinic of the School of Law, Makerere University. The mandate of PILAC, as stated also in its name, is to promote public interest litigation, public interest lawyering, to produce law graduates who are more inclined to social justice in this country, and to transform legal education from understanding legal education simply as the law as a tool of just of individual enrichment, but also of social justice in this country. So we have 3 programs in PILAC. We have the clinical legal education program, which engages students in a more practical learning of the law. We have a legal aid clinic that is run at the university to provide legal aid services to vulnerable communities around the university and within the university. And we also have the network of public interest lawyers. That one really is the umbrella body for legal practitioners who are interested in public interest litigation. And it engages in training of public interest legal practitioners in public interest litigation, as well as instituting public interest litigation cases. So in brief, that is PILAC. It was established in 2012, and we are still existing to date. We exist with support from the Democratic Governance Facility, plus an anonymous donor. Thank you.
Thank you very much. So actually, before we go into the content, let me also have Goreth just tell us what Justice Centers Uganda. It's also my way of getting to test your microphone. That when I ask you the question.
Thank you very much. My name is Goreth Ayebale, and I'm a center manager at Justice Centers Uganda, Mengo Center. Justice Centers Uganda is a government project that is supervised and hosted by the judiciary, and we provide free legal aid services to the poor and vulnerable with the aim of empowering these people, those poor and vulnerable people, to realize their rights. So basically, we sensitize them, we teach them about the laws, and we represent them in court. We do a lot of mediations, we support court. Most of the Justice Center staff are court accredited mediators. We do a lot of outreaches where the people cannot speak for themselves. We are their voices. So we reach out to communities, we reach out to polices, we reach out to prisons. We started operating in 2010. We are supported by different funders. Apart from JELOS, we are funded by DGF and UN Women. We have 12 centers across the country. At least each center is covering 3 districts. So everywhere there is Justice Centers Uganda, and our offices are located at courts.
All right, thank you very much. So the Human Rights Enforcement Act is an act of parliament that gives effect to Article 54 of the Constitution by providing for procedures of enforcing human rights under Chapter 4 of the Constitution. The law was passed by Parliament and assented to by the President in 2019. Patricia, I'd like you to start by giving us an overview of the law.
Okay. Thank you, moderator. So, in order to give an overview of the law within the limited time that we have, I'll start by picking up from where the ED left and said the observance of rule of law in this country is a mandate of each and every one of us in our respective capacities, either the judiciary, the state, the legislature, or individuals. And that is well stated in Article 20 of the Constitution, which recognizes the inherent human rights of all individuals and the duty on both the state, non-state actors, and individuals to observe human rights. Article 17 of the Constitution also enjoins citizens to, and we are the citizens, even in our individual capacities, to uphold the Constitution. And among the listed duties of the citizen under Article 17 is upholding the fundamental rights and freedoms enshrined in the Constitution. So within that context, and Uganda as a state is really has really made undertakings to protect, uphold human rights, and in the broader context also uphold the rule of law, democracy, and good governance in this country. So the duty is placed on the country, on the state, and also all the arms of government, legislature, judiciary, and the executive. Premised within that, what do we see in this Act? The moderator has already stated the broad objective of the Act, which is to give effect to Article 50 of the Constitution. Article 50 of the Constitution is that article that permits any person whose rights has been violated, or any person who knows that a right of another person has been violated, or any institution that has seen violation of the rights of any individual, to bring an action for enforcement of that right and compensation. That is, in brief, Article 50. Now, to operationalize Article 50, this Act was enacted, and some of the positives that I see in this Act, which we must commend Parliament for, is one, in the definition section, a victim is broadly defined, and this is really good, to mean a person who suffers a human rights violation, and includes the person's immediate family or dependent, or any person whose rights have been violated as a result of the violation of the victim's rights and freedoms. So that is really good, because it allows any person within these dimensions, beyond the victim, him or herself, to bring an action before the court for a remedy for a human rights violation. In law, we always speak about whether a person before the court has what we call the locus standi, or the right to bring the action. Has that person suffered the wrong? So by providing a broad definition of who a victim is, we see that it allows many people beyond just a person who has suffered the actual wrong to bring an action to recover a remedy or to enforce a human right. Again, under section 3, clause 4 of the Act, the law states that court proceedings under subsection 1 may be instituted by a person acting on behalf of another person who cannot act in their own name, a person acting as a member of or an interest group or a class of persons, a person acting in public interest, or an association acting in interest of one or more of its members. So that goes back to the earlier appreciation of the fact that the locus standi of who can bring a matter before the court is opened, and this allows for even public interest litigants. We have seen Counsel Male Mabirizi always coming to court with volumes of his documents and presenting matters in public interest. Him and others, including Cepil. I think Cepil's recent decision on the Anti-Pornographic Act is also a demonstration that people or institutions are actually interested in bringing actions for violations on behalf of others or actions in public interest. When we look at clause 4 of the Act, I ideally appreciate section 4, clause B, which says, the High Court shall hear and determine any applications relating to the enforcement or violation of other rights, duties, declarations, and guarantees relating to fundamental or other human rights and freedoms envisaged in Article 45. Article 45 of our Constitution says any rights that are not listed, Uganda is party. Uganda has ratified it. So Uganda has the mandate to observe those rights. And when you read the national objectives and directive principles of state policy within the Constitution itself, the right to housing, right to water, right to health, are rights that are recognized within the national objectives and directive principles. So that means using Section 4B, the courts can actually enforce Section 4B together with Article 45 of our Constitution and Article 8A, capital A of our Constitution. The courts can actually enforce the realization of socio-economic rights in this country. Another plus of this act is in Section 5, the enforcement of rights and freedoms by magistrates' courts. A magistrates' court shall hear and determine applications relating to the enforcement of or violation of human rights and freedoms guaranteed in Chapter 4 of the Constitution. And the section goes further to allow the magistrates' court to allow the litigants use the language that they can, that is best known to them, and then the courts can deduce that language into the language of the court. And the application by the litigant can be brought orally or in writing. These are very good initiatives in law because, one, it allows for enhancing access to justice by litigants. Litigants, as we know, or people in the community really fear the formal court processes. The formalities and our legalities in court processes deter many persons from coming before the courts to seek justice. But when you allow magistrates who are at the grassroots and more available to the local community to hear cases on human rights violations and allow them to hear oral or written applications and in the language that the litigant think is most comfortable with, then that will really improve our ability to, or our mandate in enhancing access to justice for all and ensuring that justice is actually seen to be done. There is also Section 6, Clause 3 of this Act, which allows courts, that a competent court may allow any person with expertise on a particular issue which is before the court to appear as a friend of the court, either on an application or on the competent court's own request. That is bringing in the notion of amicus. The courts allowing any person or institution to appear as amicus before the court and address the court on certain matters. That is really good. We saw this in the presidential petition, was it 2016? When we first engaged with amicus, Honorable Mama Mbabazi versus President Museveni and the Electoral Commission, that presidential petition. I remember that is the first time we saw a group of law dons appearing as amicus before the Supreme Court on that electoral petition case. So if we have that concept picked up again and brought into this act, then it's a good innovation, or at least not innovation, at least a good adoption of the role of amicus before the courts. I've seen in the South African courts, amicus, individuals or organizations play a good role appearing as amicus before the court. Furthermore, the act also provides that no suit under Section 6, Clause 5, no suit instituted under this act shall be rejected or otherwise dismissed by a competent court, merely for failure to comply with any procedure, form, or any technicalities. This is very important because it upholds the whole Article 126, which provides for substantive justice without due regard to technicalities and allows for the realization of justice. And as I said earlier, many people fear court or don't access court because of the legal processes in terms of documents, in terms of legal procedure. So if the courts are being called upon to ensure administering justice without regard to technicalities, then this is a plus that we see in the Human Rights Enforcement Act. Under Section 7, reference of human rights matters by subordinate courts. When in any proceedings in a subordinate court, any question arises as to the violation of a fundamental rights, the magistrate shall refer the question to be determined by the High Court. That may, in my view, delay justice if the magistrate cannot handle the matter in their own right, but refer the matter to the court. There may be some instance of delay of justice, but I think the legislators were also wise. In clause 7, they say the court in which reference is made shall within 90 days from the date of reference determine the reference made to it. So at least there's a time limitation within which the High Court should make the determination of the reference that has been referred to it by the Magistrates Court. And that is good because at least it gives a check. In terms of the remedies that can be provided by the court, Section 9 of the Act says, where the competent court determines that fundamental rights or freedoms have been violated, unlawfully denied, or should be enforced, the competent court shall issue orders it considers appropriate, including the order of compensation. And when you read the entire Article 9, you find that there is, rather Section 9, there is room for the court to even issue structural interdicts against the violating maybe state in this regard, and ensure that the state reports to the court periodically to show what actions they are taking in order to address the wrong. And the recent decision of Sehud versus the Attorney General and Minister of Education on the issue of teaching comprehensive sexual education in schools. Just Her Lordship Justice Mugambe, Lydia. Yes, she actually held in favor of Sehud, saying that there is need to teach comprehensive sexual education in schools in order to protect the rights of young children to these the abuses that take place because they have limited information with respect to sexual health awareness, so to speak. And she ordered that the ministry should demonstrate and show to court periodically what actions are being taken to ensure that comprehensive sexual education is included in the curricula of the schools. So you see that the Act actually gives the court the right or the powers to grant so many orders as they deem fit, and that is really necessary depending on the different circumstances of each case. Under Section 10 of the Act, it provides for personal liability for infringement of rights. It allows the court to also hold an individual personally liable for the infringement of rights of others, and not only the state, even when the individual is acting in a state capacity. In addition to the vicarious liability of the state, an individual can still be held liable. And this is important, and it's in harmony with the provisions under the Prohibition and Prevention of Torture Act, because the I think it's 2010, Prohibition and Prevention of Torture Act also creates liability on an individual, like the policemen when they beat up people or the soldiers. It gives them liability at an individual level. And I recall that it's in order to enforce this provision, there's a time Cepil actually brought a public interest suit against, as he then was the IGP of Police, General Kaihura, and 7 other commanders for the actions that torture that members of the society had suffered during the 2016 elections. This case was actually not concluded, but at least it was a first attempt to breathe life into the Prohibition and Prevention of Torture Act and hold officers in command personally liable for acts of torture that they had committed against people. Although, unfortunately, the case has not yet seen the light of day in its logical conclusion. But we see that in Section 10, that provision is still there to hold people individually liable, even if they are state actors.
Right.
So that is a plus. Yes?
You need to draw to a close.
Okay, let me go to a close. I'll then jump into maybe what needs to be done to ensure that this act that has come in with very beautiful, and let me not forget Section 15 that provides for the orders and unlawful detention of people and the need to grant orders for the release of persons from unlawful detention. That is in line with the writ of habeas corpus protected under Article 44 of our Constitution. So the act by and large is a beautiful act, and it's progressive, and it can really help us realize justice in this country. However, a number of things need to be done in order to breathe more life into this act. One, we must popularize the act. The activity we are doing today is one of the activities in popularizing the act. Some of you are here who have probably never read through this act to appreciate its provision. Judicial officers at all their levels must be trained in the utilization of this act. I engage with judicial officers sometimes in the upcountry, and there are some acts that may not be known to some of them. So there is need to have refresher courses for judicial officers in order to breathe life. The masses must be sensitized about this act and the constitution, as well as their own human rights, so that in case of abuse, in the face of abuse, they are able to come up to maybe legal officers or at the magistrate level in order to seek protection of their rights. Adequate funding of the jail sector cannot be overemphasized, both in terms of finances and human resource. It's good that we are seeing swearing in of magistrates yesterday, and very soon they will also recruit additional judges. So we hope with increased funding and both in human resource and finances, the courts will play a better role in or the entire jail sector in enforcing this act. We must also ensure adequate compensation of victims, and the state, when an award is against the state, they must pay victims in time. Sometimes we deal with victims who are not paid. They have judgment was passed in their favor, they have an award, there's money they should recover from the state, but the victim even dies before recovering that money from the treasury. So we expect the state to also rise up to the game and play its role. And then finally, we enjoin Parliament. I think it will also be important for the Parliamentary Committee, both the Human Rights and Legal Affairs Committee, to continue to monitor the application and enforcement of this act and remain a watchdog to the human rights status or compliance of the country, as well as the broader rule of law committee. And maybe to Cepil, we recommend that we should, because this instruction was given to us just 2 days ago to have this, what we are saying about this act, but we recommend that there should be a more detailed maybe study to see the enforcement of this act from 2019 to date. So I thank you all for listening to me, and that is what I had to share this morning. Thank you.
Thank you very much. And I apologize for making you rush through. It's just that we'd like to keep within the time that we said we will be spending here. Your last submission reminds me that recently we were having a conversation with Parliament around post-legislative scrutiny, because Parliament does pass laws, and Uganda is known for having good laws, but do we ever ask the question, are these laws living up to, the objective of the law, or are they curing the mischief they were put in place to cure? So yes, it's good that we actually should have those conversations around the human rights enforcement law. In fact, if I could now go over to Goreth to just look at some of those practical experiences in relation to, enforcement of the law, especially when it comes to civil and political rights.
Thank you very much. I'm going to be speaking in respect of what is happening on ground. As Justice Centers Uganda, we interact with very many organizations, and when we talk about the rule of law, you see that there are very many factors that are missing within the rule of law. So we really appreciate the fact that Uganda, we have very good laws, but the fact is that are these laws applicable? These laws always catch up with us. In most cases, if you say you don't know, you can't go and before the courts of law that I don't know. Ignorance of the law is no defense. So in whatever status you're in, whether you're a judicial officer, whether you're police, whether you're prisons, if you do anything that contradicts with the law, you're violating someone's rights. So when we go back as Justice Centers before COVID-19, the status looks to be like it was a little bit good because we had accessibility to most of these institutions. You would go to prisons and you would do your prison outreach. You would find people who have overstayed on remand and they are willing to, they want to be heard. You would present those cases to the judicial officers, they would hear them. Now, when COVID-19 came in, this is where the problem came in. There is a lot of outcry. Right now, as we speak, most of the prisons are over-congested, and there is nothing that is being done. And when we talk about the rule of law, it talks about, when you look at Article 44, the non-derogable rights, a right to fair hearing, it's non-derogable. You find that most of these people, these are the most violated rights. Even if we are saying they are non-derogable, but they are most violated. Most people who are in prisons, they have overstayed even beyond 2 years. Their cases have never been heard. When you try to intervene with the judicial officers to get to prisons so that they can hear the cases from there, they will tell you, I'm not paid to go to prison and conduct a session from there. We know we have systems in place that have been put in place, the virtual hearing, but we all know what goes on there. Sometimes the network is not good. You're in the middle of the hearing, it goes off. So you find that people are not realizing their rights, much as the rights are there. And then who enforces these rights? We all know that the people whose rights are being violated are very vulnerable. If you find prisoners who are in prisons, they cannot be represented unless someone wakes up and stands and says, okay, fine, I'm going to represent this group of people. For them, they can't speak on their own. And like Patricia is saying, if there is no funding, even the person who is interested in coming in to stand in for the rights of these people, they will be restricted. I want to give an example of most of the civil society organizations. They are challenged. Say, for example, DGF. We've all been hearing what is going on with DGF. Their funds were suspended, their activities were suspended in relation to allegations of corruption, of fraud in elections. So you find violation of one right, it's affecting all the other rights. When you look at the right to habeas corpus, it is also an underogable right. During this situation of pre-COVID, after COVID, so many people went up disappearing. We've had so many cases, so many people coming to our offices and telling us our people are missing. They let you know that the last time we saw this person, it was at a police. You try to follow up and they will tell that the police, we don't have this person. So even when you make an application, it goes in vain. So there is a lot of violation of these people's rights, of our rights as a whole. If you look at the right from torture, most of you're my witnesses, or if you have been to the detention facilities, so for example, police, people are tortured. They are tortured in front of everyone. If you look at the border guys, even if you're violating the curfew, they will beat you regardless of what is happening. There is a lot of torture. And we have the law in place, yes, but it's like they don't know what is happening. The law is there, but no one is taking an action to ensure that the rights are enforced. So the law is there. It's a very good thing. The fact is it applicable? Even if this person who has been tortured with their wounds walk before a judicial officer, and we have said that yes, it is simplified. If I come and tell you that my right has been violated as a judicial officer, you can reduce it into writing, implying that you can even bring your complaint orally. A judicial officer will tell you, I don't have that time to do whatever you're telling me. Can't you go and get a lawyer? And remember, these are people who cannot afford the services of a lawyer. The best they can do for you is maybe to refer you to an organization that they think can help you. And then when they refer you to that organization, the same organization will tell you we do not have the funding to do what you want us to do. So we really appreciate the fact that we have good laws in Uganda, the good laws that can actually be applied, but the fact is that how are we going to apply these laws? So we really appreciate Cepil, the efforts that you have put in. And in the next session is for us to assess the violation of these rights. Because we have seen much as we have the laws, the violations keep on increasing each and every time. If we have the laws in place and there is nothing that is being done, we are just doing nothing. So I call upon all the stakeholders that are here to ensure that much as we have good laws, we try and see how best we can put into effect. If we are holding the several meetings that we hold in our capacities as justice actors, we need to do them with a heart that we have to put the laws into effect, not just to stay on paper. Thank you very much.
Thank you very much. Well, it's good that both of you ended with recommendations. Therefore, it won't be necessary to come to each of you for, your final word. But I'd like to ask very briefly, is there anyone who would like to seek clarification from the panelists before I request them to resume their seats? Any question, any clarification from them? All right. If none, we were supposed to have a third panelist who was going to focus on social and economic rights, but I informed you that she had to step out because their panel was supposed to run from 9 a.m. to 10, and it had come to almost 10 o'clock when her other engagement was starting. And so we have missed her submissions, but would like to thank Patricia and Goreth for their submissions. Let's appreciate them with a hand clap. Ladies, you can take your seats. While we're having that panel discussion, we did receive the Chief Justice's representative at this meeting, the Registrar, Rosemary Barebe. You are very welcome, and we're glad to have you with us for this Rule of Law Forum 2021. Would like now to move to a presentation. One of the things that we're excited about today is the fact that we will be launching the Judiciary Performance Scorecard Report for 2020. In 2020, Cepil carried out a research on the performance of the judiciary across 24 courts in the country. And now following that research, they developed a Judiciary Scorecard Report. This scorecard report had both, the assessment was both quantitative and qualitative. Our presenter on the representation of the Ugandan Judiciary Scorecard Report 2020 is joining us virtually. I don't know if we are able to get Mr. Rogers Twesije. Rogers, can you hear me? Is Rogers online? Rogers, if you are online, you could just unmute and let me know that you can hear us.
I can hear you if you can hear me from your side.
Technical team at the back, is Rogers logged in? As we get that confirmation, Rogers will be taking us through, some of the findings in relation to the research, the survey that was done of the 24 courts around the country. He will let us know which these courts were and what it is, they were looking at to show that a particular judicial officer performed well and therefore should be recognized based on the criteria that they have. Technical team, is Rogers there? He is, huh? Okay, Rogers, I'm told you are logged in. If you could unmute so that we're able to hear you.
I'm mute on my side. I don't know if you guys can.
At certain times we have to be quite patient with the technology. Since I have a microphone that allows me to move, let me just check with the technical team. But we know that Rogers is logged in, and hopefully in a short while we will be able to hear him. Rogers, have been told that whatever the issue was has been resolved. If you could unmute your microphone and go ahead and speak. Rogers, I can see that your microphone is unmuted. However, we're not getting a sound signal from it. I don't know if you're able to hear us, could you just type in the chat that you can hear us? Okay, Rogers, I see you now have a sound signal. I don't know what it is you did. You can hear us. Okay, I think now we are able to hear you. If you could just, Rogers? All right. Rogers, if we could give it another attempt. For a second there, we were actually able to hear you saying you could hear us. So at least we are glad you can hear us. Now could we just be able to hear you? If you could say something. Okay. Rogers, let's just improvise another way. You can go ahead and start your presentation. An introduction will be good. That will help us make sure that the levels are loud enough for the participants that are physically here at the Mestil to hear you. So go ahead, Rogers. Well, from what we see here, you've been enabled to share screen. If you could just try again. We can see your screen. Let's just make sure that everyone in the room can see your screen as well. Rogers, could you please make your screen, put it in, the presentation mode? Excellent. Right.
I've been supporting through scorecards from 2019. We have from 2018, 2019, and then this one. And I'm really and appreciate that I could talk with you. I do not go back into very many details because they share the concept about where this comes from. My best case, we try to score the initial numbers. And what I will give an overview about is what the scorecard is about in terms of parameters. We look at basically 6 parameters are used to for scoring these different issues, and one of them is administration, and this is scored on the biggest term objectives. We look at partiality, also look at certainty, heavy and attitude, as well as communication. And if I would break this down in terms of what exactly that would be the scorecard, in terms of fairness,
Recording in progress.
Knowledgeable about the law and regulation, and in terms of certain try to resolve cases in time, so they have a good calendar. And in terms of behavior, that they are better than others, they always are going quite on schedule, they respect court users and users and other controls in the room, but also they explain their absence. And in terms of communication, they're able to write well in specific languages. So these are the 5 parameters that we look at scoring different issues. And I will scale them on a scale of 1 to 5, with 5 being highest and exceptional, and 1 which is usually shown that the scoring is a scale of 1 to 5. When we are presenting results, we're able to the weights to the scores, as we showed earlier, that highest is fairness, which has a partially has 30%, down the other 7%. We are able to whether someone scored only 30%, exceptionally, which is above 90%, and the others fall category as you see them there.
All right, so let's find other ways of getting this to work, because we know that, the link is working perfectly. I don't know, how many people in the room were actually registered online? Because in order to get the link, you need to register, and then the link is sent to you. Okay, because you knew you were coming physically, you didn't do that. So let's get a way of sending you the link. But as we resolve that, I mentioned earlier that we were supposed to have on the panel Alana from ISA. Alana, if you could come and just share very quickly your views in relation to the enforcement of, the practical aspects of enforcing the Human Rights Enforcement Act, especially from the perspective of social and economic rights. It will be good if you begin by telling us what ISA does, and then you can go into, the experiences in enforcing the Human Rights Enforcement Act.
Thank you. And I apologize for missing. I had a contradicting engagement. My name is Alana Kembabazi. I work with ISA, and ISA works to holistically advance economic, social rights, health, education, business human rights issues, but also, the traditional rights, housing, and all of that. And I'm excited when I got to learn that we're having another discussion of the Human Rights Enforcement Act. I feel like this is an act where COVID-19 stole its thunder. It came heavy, and then we were waiting for the president to assent. And in fact, a lot of people were quite shocked. They said, will he actually assent to it, given some of the strong language? When after he assent, we were trying to make sure it's not gazetted. But I think as a socio-economic rights advocates, for those of us who have been for so long saying, listen, the failure to deliver on healthcare or education is not okay. It's a human rights issue. This act is really a milestone for us. we know that the conditions that affect everyday Uganda. The irony is that as lawyer and as a legal profession, we have not responded in a commensurate manner. And yes, we have our constitution that has said some things, has stronger language, for example, for education, then it does argue for rights like health, but for a constitution that also has talked about just sort of, and a country that says it's moving towards development, I think the failure of the legal profession and the law to really wake up to this has really hurt our development as a country. And what excites me about this act particularly is 13, progressive realization. For those of us who have been working around economic social rights, every time you are asking, mothers are progressive realization. In fact, I reach a point where I hate that word. For what this act says is, okay, you maybe if you're not taking, you're not taking to high court, right? So it's first of all reinforcing the idea that this is, someone's mic is on, that this is justiciable in a way that reinforcing the idea that this is justiciable in a way that that is very clear, because we know that, for example, the time petition 16 was filed in 2011, this was a huge question. The Constitutional Court at the time was saying, listen, I don't think this is, there's a political question here. So first of all, it removes that doubt. And then it also goes ahead and deals with our biggest problem with this country. They always say resource constraints. And it's very clear, even if there are resource constraints, court should order the government to take measurable steps. Really, really hope to see more courts do. I like the idea of measurable, because some of the things where we say there are no resources, we never even measured. For example, ISA filed a case on persons with hearing disabilities and their failure to access healthcare because there's no sign language interpretation. But the government itself doesn't even measure how many persons with hearing disabilities can access health information, like information on HIV, right? So it is talking about measurable, like the government has to come and say, these are the things we are doing, right? And that is very useful for us, as I think is very key when you're targeting who does the buck ultimately fall to. And also provisions around personal liability. And I kept saying, yet we have an oxygen strategy that pointed out systematically about 3 years ago where all the gaps were. And so in the middle of a pandemic where oxygen is the thing you need to give someone a fighting chance, and people are dying in mass like they did in Mulago because a plant breaks down, can you hold someone personally liable? Bring him back the next day. And the guard was like, that doesn't work for me, I'm off on this day. And the pharmacist was arguing, no, this person is in pain, this medicine must be administered, on a daily. And she was like, you just know. The guard was like, we'll bring her back Sunday. And I said, do you know about this thing called personal? Because I said, we can sue you. And she said, you sue? You'll be suing government. Are you going to come for me? I said, have you heard about personal liability? So I think there's a lot of promise here. And even the remedies as well, I think they move beyond this. When we often think about remedies in this country, it's often compensation, maybe it's money, and then the government will take forever to pay. And sometimes people want you to, first of all, acknowledge there was a loss, acknowledge you did it. I like the remedy of satisfaction, which talks about restoring dignity, guaranteeing non-repetition, public apology. For some of these communities where horrendous things are happening, particularly around business and human rights, just even being able to have that come out, we don't always think about, I think, the importance of what it means when sometimes when a litigant is going to court. It is for them to also be able to say, listen, a wrong has happened. Like, it's not okay. It's not just in my head that I'm being violated. I want the wrong to be put on record. It happened. I want a public apology. And I think some of these are things we don't always think about. That I love that the Act did have quite a comprehensive section on different forms of remedy, restitution, rehabilitation. And this is the thing, though. And also has a number of things that would be really useful, like amicus. In economic social rights cases, amicus is key. The court often will want the things where it will not feel comfortable without some sort of expert opinion, but also for some of us who work holistically around these issues, you hear about this and you want to be able to contextualize this and to join as amicus. And we know that for so long it's hard. I mean, there's an amicus application, for example, we've had pending for in 2018. Right? And I like that it is tasking the Rules Committee to make rules on this and for this process to become clearer. So I think it will definitely go a long way. The thing that we continue to think about, because you do have to contextualize any legislation within the broader context of the rule of law. And I'm glad that the discussion today is going in that direction. So the question for me is, will this actually make the impact it could make in the context of a country which is really, really struggling with the rule of law? And I hope that today there are quite frank conversations around that, right? Does it make so much of an impact if we finally get this, I don't know how many years later because of huge case backlog? Or if the judgments come out and they are ignored? You know, maybe you said you're holding the permanent secretary permanently liable, and then everything gets trumped because no, you can't. So to what extent will this make an impact within the current environment we have? And what is the role of lawyers? And I think for me, the Human Rights Enforcement Act, for us at least, it's a tool. It's one of the tools in our toolkit. It, in a different setting, it may be to be one of the ones we could just really rely on. But I think it is a huge one. And the last thing I'll say is, in terms of thinking about the accessibility of this, a huge challenge we face often is people just not even knowing that socioeconomic rights are rights, later on that they can get a remedy. Like, we have internalized the fact that it is, I will go to the hospital, there will be no drugs, or they'll ask me for this, my patient could die, and nange, that is Uganda. So the extent to which we popularize things like this, they tell them, actually, wait, you have a remedy. And you can file, you don't even have to file in writing. You know, you can go and some of it you file orally. Like, the extent to which we popularize this is very important. And I know that I saw the UN, Uganda Human Rights Commission, in support of the UN, going around, talking a bit about it. I know some organizations, and I think PILAC you've done, but I know some of you all have been doing this, but I think it has to, it's beyond just talking about the act. I think when we talk about it, we have to begin to remind people that, listen, these things that you think are everyday issues, they're also rights issues. Okay. And therefore there's remedy. Thank you.
Thank you very much, Alana. Let's appreciate her. And it worked out perfectly that you came in at a point where we needed, some breathing space to try and connect with the technology. Rogers, would like to come back to you. I hope you are still there. Please unmute so that the technical team can make sure that we hear you. I've received assurances that the technical issue has been solved.
I hope you can hear me.
Yes, we can. Excellent. So if you could go ahead and share your screen. We apologize for making you do this again. But it's best that we actually understand this, because then it's going to inform the next phase we are going into. Rogers, over to you.
Screen is visible. As we indicated.
Yes, please. If you could go back to the beginning.
Is my screen big enough, or I just want one can see what I'm saying?
We can see your screen. You're on a slide that shows us the parameters. You've now exited the full screen though, the presentation mode. If you could go back to presentation mode.
Okay. Is that full screen now?
Well, you went to it and you exited it again. So if you could do what you did previously, because we were in presentation mode and we could see it clearly.
It should be on full screen. I hope that's fine on your side now.
No, it isn't. But it's okay. You know what? Let's just go with this, Rogers, because now we're really not doing well on the time. At least we can see that the screen is saying parameters.
Okay. Apologies for that. I'll try to be as fast as I can. But I just want to confirm that my voice is clear enough for everyone, that at least if the
yes, it is, sir.
All that they can hear me. Thank you. I will just continue what I was talking about last time, that the scorecard basically focuses on 5 parameters, that is fairness in administration of justice, which represents the greatest impact of justice out to the consumer, and we score this at 45, we give it a weight of 45% because of its importance. We also look at impartiality, and this considers the non-biased actions or decisions, and therefore strongly supports fairness. We look at professionalism, which strongly reinforces the desired behavior in the administration and delivery of services. We look at certainty, which reinforces confidence to the consumers or users of justice, that justice will be served as scheduled. But we also look at behavior and attitude, which recognizes the general behavior and attitude of judicial officials. And then finally, we look at communication, which ensures that court users are communicated to in a polite way. And I tried to break this down in terms of details, what we look at in terms of fairness, treats both genders equally, organizes case, organizes well the case files. He or she gives clear orders and decisions based on the facts and evidence. Partiality, we're looking at things to do with availability of case files, informs the accused of their rights, gives time for one to explain their case, and conducts unbiased proceedings. We also look at professionalism in terms of detail here, basically in terms of knowledge of the case they are handling, but also knowledge of law and regulations. We look at certainty. Here is about trying to resolve cases in due time, but also able to manage their court calendar. In terms of behavior and attitude, like I said, they are always available in court. They respect court users, but also able to explain their absence and those to recognize culture and religion of everyone. And they're able to communicate in terms of communication in a polite way to all court users. So that the 5 parameters we focus on are largely for the scorecard. And then we score this on a scale of 1 to 5, 5 being the highest and 1 being very low. And like I mentioned, but probably standing here, for the scorecard, able to apply the weights and then make 5 categories in a percentage score. And the score that I'll be sharing later on in the presentation are in this percentage, where we turn the scale of 1 to 5 into percentage scores, as in terms of poor being below 50%, exceptional being above 90%, but good or very good between 70 and 80, and something between 50 and 60, we look at it as being fair performance. We also look at quality of judgments, and this basically focuses on higher courts and high courts, and my colleague will be elaborating this more in terms of that. We also score that in terms of quality of the judgments to be able to see how the judicial officials in the high courts and higher courts performed in that line.
All right. Just a second, Rogers.
Yes,
Are you,
please.
on your end, are you still on the screen that says the parameters? Or did you leave that slide?
I left that slide.
Okay, there you go. Now ours has finally moved. Okay.
Okay.
Okay, go right ahead.
You can now see that very well.
A slide that says target respondents, right?
Yes, please.
Yes, now we can see that.
Okay. I don't know what I did.
You can go ahead now.
Okay. It has disappeared on my side, so I'm trying to sort out that. I don't know why this is becoming problematic.
So do this. Stop sharing your screen. Could you just stop sharing your screen?
Yes, please.
Now share your screen afresh. Okay, then go to presentation mode. I hope you can see it on your end.
That's what I'm trying to sort out here.
You keep going to the chat. Could you just go to the presentation mode?
You can see the screen now.
We can see the screen. If you could click, the presentation mode is right there. Yes, that one.
So now everything is fine.
Okay, Rogers, please go ahead. Please continue.
It's not full screen.
It's okay, just go on.
I was trying to focus.
And the target respondents, I hope you see that. Where I was trying to focus on the people we looked at in terms of participants, in terms of judicial officials, being the judges, the registrars, magistrates, clerks, but also in terms of other court users, being the legal professionals, civil society organizations, litigants, and also members of the local, the government, but also political circles. In terms of data collection points, we are able to focus on areas that I talked about, being the territories in terms of where the operations are for the stock scorecard, being in Central, PG, and Kampala. I'm sorry, but I can see that my screen, your screen is not moving. It is slower on probably the internet connection. I think it takes longer to move to the next page. My apologies. But in terms of areas where we were collecting data, we had 24 courts. When we looked at courts in Arua, in Nira in the north, in eastern, we looked at Soroti and Mbali. In the western, we were in Kabalole and Kabale, and also in the central, we were in PG, but also a number of headquarters in Kampala, where we had several higher courts and high courts as well as magistrates courts. And in terms of what we were able to achieve, we are able to achieve 900 interviews, majority being litigants. We had 702 legal professionals. We had 196 clerks, 70 society officials, 31 magistrates, 15 judges, and 13 magistrates. And we are also able to do at least 305 observations. And in terms of, I will not really focus much in terms of where we had many courts, how many interviews where we had, but yeah, this is the score of how many interviews being in the anti-corruption court and the lowest being at the Court of Appeal. And in terms of distribution, most of the interviews that we did, both legal professionals and litigants, were mostly at the High Court, at the High Courts, both regional but also in Kampala. And also percent of the interviews came from, and we had 9% coming from the magistrates' courts, with only 2% coming from the high courts, the higher courts. In terms of how we collect this data, we do a number of methods, basically structured questionnaires with semantic scales, which I talked about, a scale of 1 to 5, where we do face-to-face interviews with litigants who are the courts, but also legal professionals that have come for court proceedings. We also do face-to-face interviews with the judges and civil society officials, trying to scale leadership and management in terms of the judicial services and operations, and also do focus group discussions with members of the general public and selected few that are very critical in terms of cultural, political leadership, but also members of the traditional culture sectors. Like I said, we do observations and also do documentary review, especially in terms of getting the policy documents to inform the planning and the tools that we use. But like any other research, we have a number of a few limitations, and we always want to recognize this, that the skills that we use are dependent on the understanding and interpretation of the participants. So this is a limitation. We don't have control over that, but it's based on we try to explain to them what we are doing, and we expect them to understand, but we can't really have control over that. But also the user index, which is the basis of the scorecard, relies on how satisfied the consumer or the user is of the justice system. So you find that people who have been probably on the negative or the losing part may not be very comfortable, may score it based on how they have been satisfied with that. But also in terms of scope, like I said, the assessment does not cover all the courts in the country. We select a few for research purposes. And not all judges and magistrates are scored for both legal professionals. So what we present is a score, a combined score from legal professionals and litigants. But in some instances, we find that some judges and magistrates have been scored either by just legal professionals or litigants and have to be dropped from the final analysis. And of course, not all judges and magistrates are observed, but also because of COVID-19 last year, during data collection, especially in the last quarter, there were limitations, especially on how many people can be able to access the courts, which sort of brought in their limitations. So in terms of overall scores, I'll start with the higher courts, where we have the Supreme Court and the Court of Appeal. And the Supreme Court basically scored commendably, what I would call a commendable performance of 77, between 70 and 79%, which is 77 specifically. And the Court of Appeal would say fairly, they score between 60 and 9 in terms of scores from litigants and the legal professionals. When you look at high courts, we basically didn't have any high court scoring above 80%, but also we didn't have any scoring below 50%. So majority, we had two, which is anti-corruption court and non-division, scoring between a good performance of 70 to 79, but also have a number of courts in there that scored 60 to 69, the criminal division, the high court in Kabarole, commercial division, high courts in Kabarole and in PG, and then the other high courts we looked at scored a low performance of 50 to 59, high court in Soroti, family division, high court in Arua, civil division, and then high court in Mbale and Liro. And in terms of actual rankings, like we said, anti-corruption court for high court came on top with 79, followed by Land at 76, and Lira being the lowest at 53 in terms of the high court ranking. So we present this in terms of categories: courts, high courts, but also the chief magistrates courts. If you go to chief magistrates court, the chief magistrates courts, that none of the chief magistrates courts that we looked at was able to score or be scored by litigants and legal professionals above 70. So this highest that was able to be scored had a score between 60 and 69, but also we had Lira again coming low here. So specifically, we had the majority score in Arua was 69, followed by Fort Porto and PG in there, and we see Kabale and Lira coming the lowest in terms of that. So overall, and we have very many specific details of the scores in the report. So I just give a snapshot here, and the details can be found in the scorecard report. In terms of the 5 parameters, what we found that was scored largely overall in terms of litigants and legal professionals was the parameters of professionalism and fairness in the administration of justice were the ones that were scored highest in terms of commendable performance. And the other areas, the other parameters were scored probably overall on average that need to the areas for improvement in terms of impartiality, but also issues of certainty, the judicial officials in terms of continuous education, but also in terms of being able to provide what is needed for their work in terms of human resource. The other bits that were scored lowly is the court proceedings in our processes, and here we look at being able to stick on schedule, being able to manage workload, being able to communicate to the court users when things will be done. We saw that being scored low from especially civil society officials. Public trust and confidence, especially from the civil society officials, was scored very low, and this really they felt there's much to do about this, or they feel there's trust and confidence from the public, and also being able to respond to different client needs that come up. And here we looked at things about being able to collect feedback from the court users, being able to understand it, but also being able to use it to improve court processes. And these are the areas that was scored in terms of low in that area. The other bit we looked at was case backlog management, and we looked at this and categorized it in 4, where we had very extensive, which is the blue. We had fairly extensive, which is the orange, and we had not extensive, meaning it's manageable, being the gray. And then we have the no backlog, where there's no backlog at all. So if we would see that where we found the most very extensive, and just maybe to put a reminder, a context in this was collected between the last quarter of 2020. This data, I know it took longer to be able to launch it, but because of the restrictions, imbalances in the community. But we said Court of Appeal and Land having the most extensive case backlog compared to all the others. And when we looked at those that had probably fairly, if you look at courts in Mbale, civil court, the criminal division, the courts in Arua, and Kabale as well, had a very fairly extensive, but still backlog there to work on. Where we found manageable case backlog, we looked in Soroti and in Fort Porto, as well as at Anti-Corruption Court. We see that there was a fairly manageable case backlog. That we found no backlog at that time was the High Court, was the court in Soroti seems not to have really much in terms of case backlog. But again, we have this in the report that we can look at, especially in terms of how they're able to manage that. And as we move forward, we looked at the court environment, and I'll try to peruse this very fast. This was basically collected from the clerks in terms of, for instance, access to information. And what we see is that we looked at things to do about information desk available, directions about services available, guidelines in local languages, information on access to files displayed, information on bail and fees, and information on guidelines. And they are fairly available, but also we see that in terms of being able to have local languages, documents in local languages, information on access of files being displayed, information on fees and bail being just found in about half of the courts that were able to visit that either had this or didn't have this. And in the report, we are able to highlight which courts are these. Here, I just have numbers, but in the report, you're able to see where we didn't find anything at all, which is the red, and where we found that this is probably moderate, and where it is commendable performance. But these are the areas in terms of access of information that we found that were a bit lacking or still moderate, with just half of the courts being able to have that in terms of access to information. We looked at staffing at registrar's office. Again, we see a number of courts, probably 50% being able to confirm that they have enough registrar staff in there, being able to handle requests from court users at once, which are several, but also being able to have a transcriber attached. So we see 50% to 60% of the courts that we looked at being only able to have this available. And again, we see a number of them in which we're not able to have a transcriber, and even not being able to handle multiple requests in case of need, or even enough staff in the registrar's office to attend court users. The other bit we looked at was records management. While clerks admitted that they can easily find their files if people ask for them and they're easily accessible, we see that court users are not aware of the procedures and conditions to access these files. 50% were able to confirm that, and even few able to confirm that court users are aware of how bail and fees are paid. So there was a gap in there in terms of access to information, whereas the court clerks feel in case the files are requested for, they can easily find them or locate them. But in terms of awareness from the public users, they seem to be a gap in their addicts. In terms of facilitation, especially the courts themselves, we're looking at documents and equipment to guide their work. We see that in terms of being able to have legal materials that they use in the day-to-day operation, only 42% of the courts that we looked at were able to confirm that they have these materials at the court. So many of them not being able to have this, but many had the printer was available and functional, as well as photocopiers. But we saw a gap in voice recorders in need of, if they are able to do the transcribing, if they required that, being only in about 60% of the courts that we visited. So some gaps in there. As I conclude, we have a series of challenges and recommendations that we highlight in the report that are we not very different from what we found for some of us that were able to be part of the 2019 scorecard launched last year. And I will look in the report trying to highlight what should be done in terms of some of these challenges, and they remain still the same. If you look at poor remuneration, being able to, the public being fearing the judicial officials and how to be able to access the courts or information, but also fraudsters that use the names of judicial staff. We have issues of understaffing in there, and also frequent transfer of judicial officials time to time. We have issues of inadequate court space, issues of corruption and bribery that involve judicial officials, and the workload that we looked at. And we make recommendations for each of these, where we talk about increasing salaries, timely payments, increasing funding, but also equal infrastructure benefits for each country station able to work on the poor remuneration, but also sensitizing the public, especially when it comes to issues of fearing the courts and the judicial officials. Issues of fraudsters, we recommend issues of providing identification for court staff, but also again sensitizing the public about court processes. Understaffing, of course, this has always been coming up. They need to increase staffing, especially the judges and registrars. Space, expansion of court facilities, building court infrastructure, issues of corruption, the police should arrest officers involved in such acts of corruption. But again, these are things that we have been presenting a number of times at least for the 3 years that we've been talking about the scorecard. Issues of high workload, the companies need to introduce local council courts or G2 courts so as to handle minor cases and have them settle quickly and reduce the workload and case backlogs, embracing other methods such as plea bargaining and putting up courts at village levels. These are all things that we're finding again every time we go back, and they seem not to be either changing but also remain in there. The other issues of language barrier, poor file management, again, poor communication between courts and advocates and judges, issues of political interference in court cases,
As she comes, Mr. Bwambale, am I able to start with you? You're in a virtual meeting as well, huh? You tell them to mute you for now. All right. There is a second microphone over here. We're really going to be brief on this so that we can redeem some time. Please feel free to sanitize the microphones. All right, you did hear this, the highlights that Rogers has given us. Alice, I will begin with you as Daniel just sorted something out there. You did hear the highlights that Rogers gave us. General overview on the way this process happens. Does it actually bring out what the scorecard is intended to?
Hello? Yeah. Yes, thank you very much. Generally what actually I think is that I also gave this comment last time that I think it's sufficient, and the way the research is carried out, they're able to capture, I guess, like general information, right? The challenge that I find is the way I think the information that is usually especially given by the advocates, right? It's not, last time they said, what's his name, Rogers, said that I think people are afraid of giving actually their honest opinions. And there's, I think, that fear between the lawyers and, the judiciary where people don't want to I would say complain. So I was just wondering, I'm not very sure actually if they use these time papers, but what I had recommended was like a digital platform where you don't actually have to come to face to face with a person, so that it's very like the research or the interviews are very like anonymous. You know, you just send out information, like requests, and then the respondents are able to submit something without any, you know, interaction. Because if I give you information about my experience, which could have been really bad, how can I trust that actually you'll not go back to this person and, you know, share that information and then I'm chastised the next time I appear before a certain judge or
next
magistrate?
time anyone from Katende Cepil appears before a certain judge,
Exactly.
then you receive
So
the
it
backlash.
becomes a little bit hard for giving, you know, genuine information. That was my observation in terms of how actually this information is collected.
All right. I'm going to come to you on, whether the parameters, in your view, are sufficient. And they did give us the parameters. But if we could get Daniel's initial, overview.
Thank you so much. I can see their lordships and other bosses of mine here. So
You're so scared.
No. I'm in good company. The majority are my mentors. This is the second time I am being asked for my opinion on the judiciary scorecard, particularly because I'm placed at law reporting, and usually our biggest output is the decision handed down by court. So we do have analytics that show a lot of this information, including popularity or notoriety of particular cases or decisions handed down by the courts. I think Cepil, or the scorecard for that matter, still has not benefited from the current changes in the judiciary. Our Registrar for Data and Management Affairs will tell you that some of our scorecards internally are far more stringent than the parameters Cepil is using. Secondly, there's a difference between what civil society might consider useful or popular in terms of justice and what Alice, in her commercial practice at Katende Cepil, would consider a good decision or a good judge. And with this in mind, I can assure you that we have developed two key tools that will enable Cepil score us on the bench in a much better, more honest, much more confidential form that Namuli is asking for. We have the electronic court case management information system getting launched in January across the 19 courts to start with, but eventually it will cascade across the whole country. And our Registrar for Data and Management Affairs will tell you we are developing and have developed a performance enhancement tool that will be as opaque as anything. Alice will be able to type in, and we shall not know who it is who has given this review of a certain Deputy Registrar Wambali, a certain Chief Magistrate Wambali, a certain Judge Vareve, so that we move away from this pleasing our OBs and friends and barbecue mates by scoring them closely. For instance, have you been to Kotido? How does that work? And so those are some of the things I see that are gaps that Cepil might need to fill.
All right.
And it is also still very limited in geographical scope. And that also is an issue as to, a magistrate in Moyo will ask you, how do you consider only Mokono and Bija and call that the best magistrate in the country? Yes.
Okay, excellent. And I like that he's talked about the parameters because, yes, Alice, I'd like to come to you on those. And it seemed like there's also something you wanted to add. You can start with what you wanted to add and then give your comment on the parameters.
It's pretty much about me that usually the report reflects a completely different different picture from the reality. And I think first of all, because we come from a very polite society, so we naturally don't want to, I think, offend or even be open and blunt. So a system what Daniel is talking about definitely would help, like I also talked about earlier. But also, I find the percentages usually are very, again, this came out last time. Do the researchers, do they actually read the judgments? Because that is one of the most disturbing things that is happening in practice right now, that you receive a judgment and wonder what exactly happened, like how could actually a judge or a magistrate have written such a judgment? So it's
Just
and
in terms of what?
in terms of like it was obvious
Quality of writing,
the-
application of the law.
Quality of writing, that could actually be minor, but I'm saying in terms of application of the law and also in terms of actually dispensing justice.
Okay.
Because sometimes, yes, you can give a judgment and then there's a lot of struggle because of this is also usually caused by the high rate of corruption. If I've bribed a judge and I expect positive judgment,
Outcome, yes.
the judge will come up with anything, right? So usually the content, like when you read the judgments, you're like, really, how did this happen? So when you find these kind of scores, 70, 79%, you wonder, is this a country? Is this like really from Uganda, or these are scores from a completely different country? So I don't know, but something really is amiss there. And this is also something we discussed last time. So I'm just wondering if on their team they have people, or they can add people who can actually get down and maybe break down these judgments, like to improve on the quality. Seriously, 70,
right.
79? I don't know.
It's unfortunate that we didn't get a chance to listen to the person who was going to give us the highlights from the judgments, to break down how it is done. That would have informed, or spoken to your question. And unfortunately, he had to leave because of an emergency. So at the moment, I don't have the answer to that question. But I see Bwambale has something to say. And, Alice has a problem with the scores being too high. I also noticed nothing came below 50. Kept it safe at 50 being the lowest. Your view on, the marks given?
Alice is being unduly harsh.
You expected some 90s in there?
Yes.
At least for the Supreme Court, yeah?
We have, you see, unfortunately, they say Omuliamamba Omwe, something like that. One rotten tomato does everything for everyone. I've been here for 7 years. This is my 8th in the judiciary. And I can assure you the changes are almost night and day within the system. Yes, there are apples that are still bad, but they just need panel beating. And secondly, you see, like, we're a very polite society, she says. We're also unduly harsh on ourselves. The Alice's will tell you, even right from Makerere, they go to Harvard and still beat those classes. But Makerere scores the worst marks in Africa. None of us got out of Makerere with a degree. You're proud to tell to your peers that this is, okay, maybe Alice got a first class or second class upper, but the majority of us didn't leave Makerere with second class uppers or first class. Yet, for our postgraduate studies, we're the best in class. So there's that also, we over suppress the good. So I would still think, I agree with her, certainly on quality. There are decisions that come out and even us, we balk, like, what was this one thinking? Basically to the justice of the case, application of law and facts, and I don't know, basic jurisprudence. There are things that will shock the system. And all of you, including the judiciary, will recoil, because it is like moving 4 steps backwards and 4 steps forward and a full marathon backwards. Those are some of the issues I think need to be sorted. But as far as the scores are concerned, 79%, I still would think there are people who can score even higher than that. if we had a broader scope of respondents or subjects to look at that was scoring.
And those are things going to be taken into consideration. Let's end with, the parameters that were given: fairness, impartiality, professionalism. I think this is behavior and attitude, communication. Are these sufficient in your view? Are there parameters that should be added that would give a more holistic view? Alice?
I think actually the parameters are they're within. I mean, it's. I guess
Okay.
they are all justified. So I would.
Daniel, do you have any contrary view?
No, we
like to say we
think-
don't have anything useful to add.
I do not have anything useful to add. Yeah.
All right. I will get final recommendations from both of you. Alice first. It's the final thing you're saying, and then you.
On final recommendation
Yes,
report.
yes. And
for-
please do not mind repeating something you said last time, so that it is actually implemented. We also take note that this was done before the launch, and therefore some of these things may be captured in the 2021. So yes, Alice.
For me, usually the missing link is more of actually how, especially I think, how we can capture how corruption actually affects the system. Do you understand? And clogs the system and actually prevents the system from dispensing justice. Do you understand? Like from everyone in the system, because I find that right from the person, the clerk who receives your documents, Supreme Court judge, the system is like blocked. It's accessing justice through the system is so difficult, because it can only be done by payment. So if you pay something, that's when you're able to get. I just wish they could just follow the system from the point of the clerk. Like actually how does someone receive justice in our system? You'll be very surprised with actually the results. And shouldn't it just be? It shouldn't just be the score of. The final score depending on the judgment, because it's a whole system. By the time I get the judgment, I could have gotten the judgment 10 years later. A very good judgment, whereby the events have actually already, been overtaken. Rather, the dispute or the dispute has already been overtaken by events. But I've got a very beautiful, well-written judgment 10 years later. So the question is that what is that actually prevents me from obtaining justice? And what are those things? I'm just thinking justice can't be, or a judgment is just not only, the written part or how well or how eloquent this person was. Because when you point out all those things, I think you end up actually getting a more, fairer report, and you're able now to understand how to solve these problems. Because it seems we are solving the problems from the top, yet the things that actually affect the system are at the bottom.
Okay. Thank you, Alice. Daniel?
You see, Alice is a partner in one of the best law firms in this country and probably East Africa. So when
I'm
she
surprised
speaks,
she hasn't gotten the microphone to say the best. Remove probably.
no, it is probably the best.
Probably, okay.
Yeah. So when she speaks, we ought to listen. You see, for the judiciary, we suffer from corruption and a perception of corruption. I would like to think for even the lower bench, the majority is a perception of corruption. But a practitioner such as Alice is better suited to actually score us on whether we are corrupt or not. So I would not speak so much about that, apart from pointing out a few things. Number one, we are going to do away with person-to-person interaction once we start the electronic court case management information system. Alice will be here and she'll be able to relay her submissions on her phone while she's speaking. even her decision will be rendered and will appear to her phone. Basically, starting from payment of fees, etc., you will not be able to see so much interaction between Alice or her process server and the clerk. We think this will work in our favor as the judiciary. Also, we just had the Administration of the Judiciary Act passed last year in June. In fact, it commenced on 19th June 2020. We are right now, I'm putting on, I have a new tie because we got a better salary. And we have had, I mean, when I joined the judiciary, I think the Chief Justice Benjamin Odoke was earning 5 million, but now that is the base salary of the new grade ones being sworn in. And this was 8 years ago, so it's not so far back. What I would like to think Alice and the practitioners in civil society should be doing is to look at justice as a 360-degree thing, not necessarily the judiciary. Look, we have recruited 92 grade 1 magistrates this month, and the DPP's office informed us on Tuesday that they lack 181 prosecutors because according to the public service, because they are part of the executive arm of government, there's a recruitment ban on prosecutors. So we're going to deploy these children to courts and they'll be rendered idle because there's no prosecutor coming in to prosecute cases on behalf of the government of Uganda. You'll have a CID that does not conclude investigations. And now we're talking about really, really basic principles of justice. A defilement case, an arson case, assault, occasioning actual bodily harm. We're talking about basic justice in Buseruka, all those villages. We are not getting that. So we have a well-resourced judiciary, but not a well-resourced criminal justice or even civil justice system, which is affecting us. So we have a well-paid bench with poorly paid clerks because someone somewhere is not doing their job and effectively interpreting Section 13 of the Administration of the Judiciary Act and transferring all our workers back to the judiciary service. Incidental, as of June 19, 2020, these are members of the judiciary service. So someone somewhere is not doing their work. This is 1 year later, 1 year and a few months. These are things now Cepil should look into and say, look, legislation must go like this. Why are we still having, this is a $40 billion economy. Why are we still having a grade 1 magistrate who is paid over $2,000 in salary and allowances per month, handling a case of 20 million? In Kenya, in 2007, when it was a $40 billion economy, a grade 1 magistrate was handling cases of 150 million Ugandan shillings, if we convert the currency. Right now, they are far and beyond that because their chief magistrate, I think, is at 750 million. I know, I did the research, and I wrote a paper about it. So these small, you talk about backlog, but you're making a Justice Kazare suffer with land plots in Kira of 65 million. I also have a plot of 65 million. I mean, I can handle that case. Why is it at the High Court level? Why don't you amend the Magistrates Court Act? So these are key points that shouldn't just look at the parameters of fairness, impartiality. We are so many who are fair, who are impartial, who can apply the law to the facts, who are very well educated, who are not corrupt. But without these executive and legislative bottlenecks being resolved, these scorecards are good for us, but they're not going to impact delivery of justice. And that's where I think you guys need to really put emphasis. How many Cepil guys know the office of the Public Relations Office of the Judiciary? Do they go there? Do they have our annual report? What have they gleaned from that annual report? What are we supposed to achieve in the strategic plan number 5? Why, are you putting us to those tasks? Are you saying, you said you'd recruit 400 magistrates. How many have you recruited? You said you'd have 150 judges. How many do you have? Why do you need 150 judges? If you have 150 judges, how many prosecutors are needed? Those are the questions. But as far as the parameters are concerned, I think they're okay in terms of evaluating our individual and corporate performance. I thank you.
Thank you very much.
Can I say something?
Yes.
Daniel is very proud of the fact that the judiciary, their salaries have been increased, and so so many of the problems are going to go away. I don't think it's true. You know why? Because if you pay someone, if you increase my salary, and I am weaved, my brain is wired to be corrupt, that is not going to change. In fact, it's actually going to get worse, because now I'm used to if I was paid 5 million and now I'm being paid 20 million, that means my bribe my fees are going to go higher. Do you understand? Yeah. Actually, yes, of course. I'm not saying that the salary shouldn't have been increased. It was long overdue, and it's extremely important that it's been done, right? But that is not really actually solving the problem of corruption, because there are other issues which are embedded. Corruption there's a way it's embedded in our society that even like a 0-year-old is, suckling it from their mother's breasts, and that is how it is. Like you go in primary schools, and the children are bribing each other with sweets to vote for each other, and no one is actually taking record of that. So how are you, even though you pay judges or magistrates a lot of money, the way corruption is embedded in our society, I don't think definitely there will be a big solution to that. And also, if the judges and magistrates and lawyers and the litigants, actually whoever pays, there's no implication. All corruption laws are not enforced. Then we are wasting time, completely wasting time.
I agree with you on the fact that paying a higher salary is not necessary. Otherwise, we wouldn't have people like Chandi Jama in Luzira today. But we can say without fear of contradiction that it also, a lot of our corruption might have been necessity corruption. You send a person to Kabera Maido earning 1.2 million and his family is in Kampala. Maybe it is something we discussed and even gave our views to Parliament when we were trying to have that act, the bill passed into an act of law. If anything, the recruitment process by Judicial Service Commission and how many of the old practitioners are dying to join the judiciary, it shows that pay is important. But also, when you look at internal systems like the Registry of Debt and Magistrates Affairs, Registry of Inspectorate, etc., we have almost a zero tolerance now because there's no more excuse. You're going to say you took a peasant's 200,000 for what? You're earning 5.2. That is what helps the people who are in charge, like Barebe, stop smiling with you now. Because last time they could have said, okay, maybe his wife had just given birth, then he had a broken leg. They could have said, severe warning. Now they're going to say, go to JSC, and they'll recommend to JSC dismissal. So that helps the pay, in a way, is a weapon in the hands of administrators.
All right.
To whip.
Okay. Lady, gentlemen, thank you very much. Let's appreciate them. All right. I was reading the National Integrity Survey, and ladies and gentlemen, would like to move to the next session, and would like to continue to recognize the presence of everybody that has joined us, whether physically or virtually. We have a number of judicial officers with us, justices from the Supreme Court, the Court of Appeal. In fact, Justice Alexandra Nkonge did come with her husband. Would like to thank you for actually coming along with your wife. And we will later recognize, the justices and the judges, and if we have any magistrates present with us. I informed you earlier on that Her Worship Rosemary Barebe, is here representing, she's a registrar and she's here representing the Chief Justice, and I believe she has the Chief Justice's speech. Well, one of the things that Cepil has done through this period is, come up with the Rule of Law Champions Initiative. These are young lawyers who are being, mentored so that they can be exemplary, and this is really to see how they can strengthen the rule of law in the country. They've been through the program, and I'd just like to recognize those that are present with us, and we'll have one representative from them to just give us a very short presentation on what it is they have been able to do. These are Mr. Nuamanya Joshua. Joshua, wherever you are, if you could, in fact, you come to the front. Nachisinde Alice Mary, please come, please come. Tumusime Shelina, excellent. Aromorach Fancy Sheila, and Sentongo Yakubu. Excellent. Who of you is making the presentation? Okay. Is it at the back? Do they? Okay. If you could just project that, please get a microphone and you represent your colleagues. To make sure that it's short, we are all standing here, and we'll start to complain if you make us stand for long.
Thank you. All protocol observed. I greet you all in your different capacities. We are the rule of law champions. They've already introduced us. I'm going to make a presentation. We came up with this from the different articles that we submitted to the Cepil. Please go to the first slide. This is a brief introduction. We introduced Cepil as a non-profit organization, non-partisan, non-religious organization that upholds the principle of good governance. Cepil envisions Uganda, a Uganda where rule of law is practiced and nurtured in public interest. Cepil, through rule of law thematic area, came up with a Rule of Law Champions Initiative, where we are parties. The Rule of Law Champions Initiative is a program where young lawyers are equipped on various concepts on rule of law. This year's program attracted 5 young lawyers of different backgrounds. The 5th person has not come today. We are 4, but we are 5. The gentleman called Yakub. From the training, the participants came up with articles identifying problems in affecting rule of law and possible solutions. These articles are the basis of the presentation today. Just please go to the first slide. Under Article 1, the state of the media. This is the first, it's the first one. The state of media and press rights to freedom of expression under the constitutional principle of rule of law. Here, we identify the problem and find a solution as displayed. The first problem is the 2021 general election were characterized by widespread violence and abuse of human rights, including abuse of journalists. The second problem, we have seen now and again that journalists get beaten and arrested for doing their job, for example, on NTV, the correspondent John Wycliffe Wamala. And the third, the shutdown of the internet also affected the dispensation of information to the public, and this affected the media. The solutions are here. The first solution is we got the amendment of the Press and Journalists Act of 1995 to capture the current state of media issues. The second solution is severe punishments to violators of human rights, especially those related to media rights. And the third was implementation of Human Rights Enforcement Act of 2019 to its fullest. That's it for the first article. The second article, the heading, a letter to civil society organization on rule of law in Uganda. The first problem there under is civil society organizations are not doing enough to promote rule of law. The second is so much has happened in the country that has put the state of rule of law in the spotlight. And the third is the example, human rights violations, failure to hold members of the government accountable, monitoring money donated or borrowed on behalf of the government, poor access to justice, among other problems. The first solution is, this is however what civic space can do. The second one is have internal policies that superintend to the works of organizations. The third, adopt other measures other than litigation to promote rule of law, such as setting up impartial committees to look into some of these violations and demanding the government to work to make right what is wrong. And then the fourth is COCs should engage the youth in the promotion of rule of law, incorporate a youth policy in organizations. The third article was on enhancing access to justice through technology. The problem, the first one, access to justice takes many forms, such as ability to access court effective and timely disposal of cases, enforcement of court decisions. The second, disposal of cases in the country takes roughly 3 to 4 years. The third, access to court, especially during the pandemic, was affected. And the first solution is adopting e-justice, for example, hearing of cases online. The second is delivering of judgments online through video conferencing platforms such as Zoom. And the third is training of staff, litigants, and lawyers about ECI-MIS systems. And then the last solution is funding for IT equipment, both in rural and urban courts of law. The fourth and last article is observance of rule of law through an absolute separation of powers. The problems, the first, separation of powers envisages the three arms of government operating separately but working together. And then the second one is the executive has seen interfering in works of both judiciary and the legislature. For example, sending security personnel to parliament during age limit plenary, arresting litigants, awarding bail by the judiciary, among others. The third, the appointing authority is vested in one arm, hence giving the arm more authority than others. Then lastly, having members in more than one arm of government. The solution, the first, an absolute separation of powers is ideal for a state like Uganda and will strengthen the rule of law in the country. The second, an amendment of the constitution to reduce on the appointing power given to the executive. An amendment, and the third is an amendment to the constitution to include a sanction for arms of government that act ultra vires. The fourth, an amendment that prohibits someone from holding more than one position in an arm of government. And the last but not least, modifying the notion of separation of powers instead of three arms. A fourth arm should be created acting separate from the others. Thank you.
What's this fourth arm? Security. This concern is about the security in Parliament.
Yes.
Well, there are ministers who are in a different political party but serving in another, but I will not go into that. I'd like to give Joshua a microphone. Sorry, this is a total ambush, but we're going to use less than a minute. So please answer very quickly.
Okay.
What was your engagement with Cepil as young lawyers?
How was our engagement?
What?
Our engagement with Cepil was mostly equipping us on the knowledge of rule of law, particularly the state of rule of law in the country.
Okay. And what did you learn?
We learned so much, and from that, because you can see that we came to understand that the state of rule of law in Uganda is not that good. And this is also indicated in the periodic, how should I call it, rankings of Uganda in regards to rule of law. And yeah, we have come to understand that rule of law in Uganda is not ideal, and we need to do so much to strengthen it.
All right. Is this important for other young lawyers, or just a few should go through this kind of program?
Definitely, definitely. I believe also here my colleagues will confirm to that.
All right. They will confirm by nodding. Okay. They won't say anything. Let me have the microphone back. Thank you very much. You are going to be, you being champions doesn't end here. Please go shine the light wherever you go. Let's appreciate them as they go back to their seats. Yeah, I saw the rest were fearing that I was going to also pass a microphone to them. All right. Ladies and gentlemen, I would like to very quickly go to the next thing on our agenda, which is a keynote speech from the board chair of Cepil. She's joining us online. This is Ms. Robina Namusisi. Robina, can you hear us?
Good afternoon.
Because right after,
can you hear me?
Yes, we can. Robina,
yes,
you have the floor. Please go right ahead.
Okay, good afternoon, and thank you very much for having me join this very important. And I'm very honored to be giving the keynote address on behalf of Cepil. So, the guest of honor, the Honorable Justice, Chief Justice of the Republic of Uganda, the Honorable Principal Judge, the Honorable Minister of Justice and Constitutional Affairs, the Honorable Attorney General, the Justices of the Supreme Court, the Justices of the Court of Appeal, the Judges of the High Court, Your Excellencies, the Ambassadors, Heads of Constitutional Commissions, Heads of Jealous Institutions, the Chief Registrar, the Secretary to the Judiciary, the President of Uganda Law Society, Your Worships, members of the Bar, distinguished guests, ladies and gentlemen, welcome. It is my singular pleasure on behalf of the board of the Center for Public Interest Law to welcome all of you to the Rule of Law Forum 2021. We are honored by your presence, participation, and invaluable efforts to the continued promotion of the rule of law in Uganda. Cepil envisions a Uganda where the rule of law is practiced and nurtured in public interest. Our mission is to be the leading catalyst for social change in the political and economic sphere through research, advocacy, public interest litigation, technology, and legal aid for vulnerable groups in Uganda. We have been at the forefront advocating for progressive reforms aimed at strengthening the rule of law, implementing a project premised on the need to address human rights challenges in the country. Part of our activities today under the these thematic areas is the Judiciary Scorecard Initiative, the Human Rights Law Review, and the Rule of Law Champions Initiative. Ladies and gentlemen, a key activity on today's agenda is the Judiciary Scorecard Initiative, designed to provide a framework for appreciation by the citizenry of the administration of justice by the institutions of the judiciary in Uganda. The research gauged performance of these institutions from the service delivery perspective based on fairness in the administration of justice, impartiality, professionalism, certainty, behavior and attitude, as well as communication by judicial officers. The research employed a combination of techniques. The first one, the analysis and evaluation of case management data through analyzing court statistics as per the set targets per the judge or magistrate vis-a-vis the overall strategic plan. The analysis also looked at court user satisfaction surveys, court user satisfaction surveys involving litigants, professionals who particularly participate in court proceedings, institutional stakeholders such as the Ministry of Justice, DPP, RCC, DCC, private practitioners, bailiffs, police, prison, Office of the IGG, human rights organizations, religious and district leaders, CSOs, and legal aid clinics. The other technique was courtroom observations, using a structured checklist administered in all targeted courts. There were also one-on-one interviews with judges, magistrates, registrars, court clerks to try and establish a buy-in by these members to overcome imminent resistance to the final outcome of the study and enable the participants to candidly talk about some of the issues that may not be captured using other techniques above, and also to uphold a balanced assessment of the issues at hand while leveraging their experience in court, plus their observations and recommendations in line with the objective of the study. The research also conducted judgment reviews used to score the effectiveness and efficiency of the institution of the judiciary, and examines the transformative role of the judiciary through analysis of selected judgments from a section of the participating courts. The objective is to assess the performance of judges of the High Court, justices of the Court of Appeal and Supreme Court on the basis of the judgments that they have issued. There are also focus group discussions that were convened to identify quality indicators for service delivery. The Judiciary Performance Scorecard Report 2020 therefore provides an assessment report of the key performance parameters for measuring judicial officers, and more importantly, what the parameters reveal about the officials in terms of their weaknesses and strengths in the delivery of services to consumers and users of the justice system. The data collection process by research assistants was conducted over a period of 4.5 months in 24 courts across the central, eastern, northern, and western regions of Uganda. I would like to share the key highlights from the report. The scores by litigants for higher courts showed that the Supreme Court had a good performance at 79%. The legal professionals rated the Supreme Court at 77%, and as the legal professions rated the Supreme Court as for outstanding performance at 77%, and the Court of Appeal at 69%. For the High Courts, litigants scored the Anti-Corruption Court at 78%, followed by the Land Division of the High Court at 75%, while the legal professionals scored the Anti-Corruption Court slightly higher than the Land Division of the High Court. The assessment for the magistrates' courts by litigants scored Arua Chief Magistrates Court at 78%, followed by Mpigi, while legal professionals also scored Arua Chief Magistrates Court's highest, followed by Mbale. We also commend the judicial officers that were identified in the report as top performers. These, and allow me to recognize those that were identified as top performers among the magistrates and the judges. The Honorable Lady Justice Lilian Tibatemwa Echirikubinza, the Honorable Justice Paul Mugamba, the Honorable Lady Justice Stella Arach Amoko, Honorable Justice Frederick Egondantende, the Honorable Geoffrey Chiriabwire, Honorable Justice Kenneth Kapuru, Honorable Justice Musa Sekana, His Worship Paul Kedi, His Worship Susan Adong, and His Worship George Watechere. Thank you for the great work you the honorable judges and magistrates. Ladies and gentlemen, for the third Human Rights Law Review 2021, we are examining the enforceability of the Human Rights Enforcement Act 2019 before, during, and post-COVID-19, and the democratic processes like the 2021 general elections in Uganda. It is worth mentioning that there were serious human rights violations in the general election period and also during the COVID-19 pandemic, most of which have not been accounted for to date, despite the enactment of the Human Rights Enforcement Act. The dialogue was determined to understand the efficacy in addressing human rights issues in Uganda. Lastly, Cepil, through its thematic area on youth and the law, started the Rule of Law Champions Initiative, where it seeks to impact and mentor young lawyers on how to strengthen the rule of law in the country. Despite the shortcomings as a result of COVID-19, we have managed to conduct the initiative virtually. The champions were taken through an intensive virtual training program, and this included an assignment involving research on the state of the rule of law in the country. The findings have been combined into a report titled The Rule of Law in the Youth Perspective 2021. The champions are here today and will be awarded certificates of participation and course completion. I would also like to take this opportunity to commend the Rule of Law Champions 2019, who have continued to promote the rule of law in their various capacities, and at the same time came back and mentored the champions of 2021 in order to leverage the use of digital platforms and ensure continued learning. The Rule of Law Champions Initiative mentorship program is now online via an online self-paced course, accessible free of charge. Allow me, in conclusion, to thank the Ford Foundation East Africa for their partnership. I would like to encourage members to get the report, to see the layout of the scores of each court that was scored, and the Rule of Law Journal by the Rule of Law Champions 2021. Once again, I welcome you to the Rule of Law Forum and take this opportunity to invite our chief guest to make his address and launch the Judiciary Performance Scorecard Report 2020 and the Rule of Law Journal 2021, as well as officiate the awards and certificate ceremony. Thank you very much for listening to me, for God and my country. Thank you.
Go to the remarks which were prepared and given to me. Distinguished participants, ladies and gentlemen, it is my honor and pleasure to address you today during this annual event and during the occasion of the launch of the Judiciary's Scorecard Report of 2020. I am grateful to the organizers, the Center of Public Interest Law, for inviting me to speak once again during the launch of the Scorecard Report. I'm delighted that despite the situation presented by COVID-19 since last year and to date, Cepil were able to traverse the country and collect data, leading the report now before us. I'm grateful that we are now here to take stock of what is happening in our courts and to learn some strategies on how to enhance access to justice in Uganda. I'm informed that different parameters were used to collect data on how various courts and individual judicial officers performed during the year under reporting. These parameters, among others, included fairness, impartiality, certainty, professionalism, behavior, and communication. Some officers, according to the report, excelled, and others ranked lower. This is only a learning point for us to pick lessons from, needed for our work, and this information is useful for us to reflect on how we exercise our judicial functions in the eyes of the court users. The report is balanced, and I believe it is not in any way to demoralize judicial officers who have ranked lower than others. Neither should it make those who have excelled to relax. I note that the scorecard is aimed at promoting access to justice and enhancing judicial performance at all levels. We must continue to remain accountable in our work to the public and allow public scrutiny to inform our actions, always in the exercise of our judicial mandate. In that regard, the Constitution of the Republic of Uganda, 1995, provides that judicial power is derived from the people, and everything done by the courts should be in conformity with the law, the values, norms, and aspirations of the people. I note that in 2020, Cepil launched a report which highlighted key recommendations, some of which have been implemented. We have embarked on regular supervisory visits to all courts across the country, and gradually we will attain the required customer care mark. Today, this report is fortunately launched at a time when the judiciary has enhanced support from the state. As you may be aware, last year, the government of Uganda passed the Administration of the Judiciary Act 2020, which has given the judiciary the opportunity to embark on improving access to justice in Uganda. The new law provides an opportunity for partnerships with many justice actors and civil society in the promotion and enhancement of access to justice in the country. In the previous year, Cepil had pointed to the inadequate use of IT-centered services in our courts, and on this note, I must report that we have launched the use of the Electronic Court Case Management Information System, abbreviated as ICMIS, and we have carried out training for both judicial officers, lawyers, and non-judicial staff, and we shall continue to roll it out in all countries, in all courts in the country. This system provides for e-filing, for a digitalized court, for e-court recordings and video conferencing, digital presentation of evidence, e-libraries, and enhances user interface between court staff and the public. It is my hope that with ICMIS, perceived or actual corruption in the judiciary will be eliminated, especially where an effective contactless electronic court case management system is in place. It will also improve on our monitoring and evaluation systems. Tracking of case files in the system will also be eased. There is currently evidence that we have at least a case backlog reduction of about 4%, which is 4% in the year of 2019-2020. This is arising from a deliberate policy to fast-track cases such as those related to sexual and gender-based violence, then homicides, commercial and land matters, among others. The courts have continued to exercise their mandate despite the recent spikes in the cases of COVID-19 in the country. Like many other entities, the judiciary also experiences operational challenges, some of which may require concerted efforts to overcome. These include sensitization of court users on court processes and inadequate numbers to meet the ever-growing justice needs in the country. I am confident, however, that entities such as Cepil come in handy to close the information gaps in the administration of justice. In view of this report, building a pro-people service delivery requires participatory information gathering, dissemination, and implementation. There's no doubt that an informed and accountable and reliable justice system promotes sustainable development and stimulates economic growth in the country. Furthermore, the ripple effects of the public trust in the justice system opens opportunities and attracts foreign investments into the country. I'm confident that with the new law in place, that is the Administration of Justice Act 2020, the judiciary is mandated to explore avenues for stakeholders' engagement as envisaged in Section 2 of the Act. In that regard, the scorecard may act as a stimulus for high performance and may be a measure for success in our everyday adjudication of cases. We welcome the assessment and the recommendations which have been made in the report, and we will give our attention where it is required for better results in the next period of reporting. We request our partners to always disseminate the findings of the report, share them with many stakeholders in a bid to collectively support the administration of justice in the country. I therefore applaud the organization of Cepil for taking up this initiative every year for us to take stock and reflect how we performed as an institution and also as individuals and as courts. This annual event creates an annual tracker, increased pro-people-centered justice, and information dissemination. With these few words, allow me, it is my singular honor and privilege to declare the Scorecard Report 2020 as launched. I thank you all.
Would like to thank very much the Chief Justice for sending us those remarks, and would like to thank Her Worship Rosemary Bareve for delivering those remarks on behalf of the Chief Justice. Please send our appreciation back to the Chief Justice. Yes, you have declared the report launched, but would like to do something symbolic. If you could come to the front here, where you'll sign a copy of the report. And we'll take the seat in the middle so that they're able to get the backdrop over there. I'd like to ask the team from Cepil to avail the copies that are supposed to be symbolically launched. If you could make those available so that we can have them signed as we prepare to let you know those who will be awarded following the scorecard. So first, we'll be launching the Judiciary Scorecard Report. So today there are two things being launched. There's the Judiciary Scorecard Report and then the Rule of Law Journal. So those are the two publications that are being launched, and we hope that at the end of the day you will be able to go with a copy of each of those. As Rogers was presenting, He did give you highlights, but he kept saying, get the report and read the details. I hope you'll be able to actually get the report and read the details. For those that are joining us virtually, you can let us know how we can avail you with your copy of the reports. So if you could just put that in the chat, we'll make sure that we find a way of getting a copy of the reports to you. Justices present have been requested to hold on because they'd like to give you copies of the report and take a photo of you holding the report. So they've gone to bring more copies of the report in order to facilitate that. As the board chair was giving her remarks, she mentioned that the champions will be recognized today. We actually have certificates for the champions. We will be giving those certificates. You can go ahead and give the justices copies of the report. All right. How would you like this to be handled? Okay. Would like to have a banner in the background. So I'd like to invite you, if you could come to the front of the table. Request the representative of the Chief Justice to still stay at the front. There's just one more thing we'd like to ask you to do, and that is give certificates to the champions who we called earlier on. And if you could just stand up right now, and we will call you, each of you will receive your certificate from Her Worship, Rosemary Barebe. Did you say Sentongo Yakubu is not here? All right. Aromorach Fancy Sheila. Niwamanya Joshua Mugisha. Tumusime Shelina. and Nakasinde Alice Mary. Mentors were engaged to actually train and guide these young people. And so we'd also like to recognize and by giving certificates to the mentors as well. Is Akulu Esther with us? Thank you very much for the time and effort you put in to prepare these young people. Aber Ruth. Let's appreciate them. Atukunda Rita Katureve. Muranga Brenda Atwoki. And then Chisula Gad Atha. One of the champions wanted to be the last person to receive the certificate, Tumusime Hilena. We're going to end today by just letting you know the judicial officers that are being recognized for outstanding performance. And we're just going to read their names out, but they will be presented with their awards. These will be sent to them. We hope we can get a date and a time with the Chief Justice to be able to give these tokens of appreciation and recognition to the following judicial officers. I will start with those at the magistrate level. His Worship, K.D. Paul, and if any of you is present, just for us to recognize your presence and to appreciate you, we will appreciate it if you could stand so we can see you. So His Worship, K.D. Paul. All right. Her Worship, Adong Susan. We can still clap for them even if they are not physically here. His Worship, Watie Kere George. Okay, also not present. From the High Court, Honorable Justice Musa Sekana. And thank you for making time to be here. Honorable Justice Lydia Mugambe. Honorable Justice Olive Nakazarwe. No? I beg your pardon. I'm really sorry. Honorable Justice Olive Kazarwe. Yes, I apologize. Honorable Justice Alexandra Nkonge. Thank you very much. From the Court of Appeal, the Honorable Justices that are being recognized for outstanding performance, the Honorable Justice Engonda Ntende, not present with us, the Honorable Justice Kenneth Kakuru, and the Honorable Justice George Chiriagwire. I see consistency here because I think I had the honor of also doing this at the 2019 awards, and some of these were actually recognized at that time. And like the Chief Justice said in his remarks, you know, those who have performed well should continue, and it's good to see that some of these names do come up again. From the Supreme Court, the justices being recognized for outstanding work, the Honorable Lady Justice Lillian Tibatemwa Echirikubinza, the Honorable Justice Paul Mugamba, and thank you for being here physically, and the Honorable Lady Justice Stella Arach Amoko. Thank you very much, and like I said earlier, we hope that we can get a date and a time suitable for the Chief Justice to be able to hand your awards to you. Ladies and gentlemen, we've come to the end of the 2021 Rule of Law Forum and the launch of the Judicial Scorecard. Would like to thank you for joining us physically and those that joined us virtually. It is our hope and prayer that you will continue to uphold the rule of law in your various capacities. On behalf of Cepil, whose board you did hear from and whose executive director you did hear from, Cepil is grateful that you honored the invitation, and we